Welcome to this special edition of Hub Hits. I'm Harrison Lowman, managing editor of The Hub. I'm so pleased to be interviewing Professor James Kelly today, the author of Constraining the Court, Judicial Power and Policy Implementation in the Charter Era. His book has been shortlisted for the Donner Prize. His book is right behind me here. He's also professor of political science at Concordia University. The Hub is very pleased to be partnering with the Donner Canadian Foundation. Well, we will be spotlighting over the next few days the authors who are shortlisted for this year's prize. James, thank you so much for joining me today. Or I'm supposed to call you Jim. Jim, how are you doing today?
Jim is good.
Congratulations.
Thank you very much. It's a tremendous honor to be nominated for the Donner Prize this year.
So give us a sense of the message you're trying to get across with your book.
Well, the book is really about the need to look beyond high-profile activist judicial decisions. So when the Supreme Court of Canada invalidates statutes, give you an example, when the Supreme Court ruled on medical assistance in dying, a very high-profile decision and tremendous implications. What my book wanted to see is whether or not activist judicial decisions, when they strike down legislation or impose responsibilities on government, actually see a policy impact. And so my book is really about looking beyond a high-profile judicial decision to see how Parliament or a provincial legislature responds, but more importantly, to see whether or not there's any policy impact traceable to the court's decision.
Can you explain to us, and this is a tale as old as time, the inherent tension between courts and judges versus politicians and legislatures?
Yeah, I mean, part of the tension is in Canada, and we straddle multiple strands of constitutionalism. You know, we have the principle of parliamentary supremacy, which is most manifest in the notwithstanding clause, which is now part of the political discourse. 1982, we see the transition to constitutional supremacy, though we've always had elements of parliamentary supremacy because of the Charter and the notwithstanding clause. The question, though, and this is what my book is really trying to answer, is have we gone beyond that? Are we seeing perhaps judges overstepping their role in a constitutional democracy, and perhaps Canada's gone one step beyond towards perhaps judicial supremacy? And so my book really tries to look at those inherent tensions. Ultimately, my book concludes that at the end of the day, even when the court is activist, we should not assume that means Canada's moved beyond constitutional supremacy. The reason being, ultimately, it's legislatures that decide how and if to respond to judicial decisions. And so to make one further point, my book is also really about the continued importance of federalism. Because when we think of the Supreme Court of Canada invalidating a statute, Canada is a very complex federation. Sometimes a response to a judicial decision requires sort of a legislative response by Parliament, as well as a policy response by the provinces and the legislatures. And as my book argues, that there can be these very complex implementation chains because of the complexity of Canadian federalism that might negate a lot of the potential negativity associated with judicial invalidation of a statute.
Mm-hmm. You mentioned some buzzwords here that you see pop up when you start reading about courts in Canada. Activist judges. What defines an activist judge? Like, how does one get that label? Or, what makes your ears sort of perk up when you're reading through decisions and gets you saying, okay, there might be something there?
I'm not sure I would use the labels in regard to judges. I think using those labels tends to be, say, a political scientist, political perspective on what the role of a court is. I mean, you can have both. I mean, the view is sometimes that judicial activism is the court being progressive, changing the meaning of rights and freedoms. Mm-hmm. That tends to come from, say, conservative judicial critics. Those that believe that the Constitution should be, narrow. The role of the courts is simply to apply the Constitution as it's written. There also can be conservative judicial activism when the courts maybe reduce the scope of rights and freedoms. So again, to go back to your question, I would say the label, I think it's more in regard to the individuals making analyses of the court and their role in a constitutional democracy.
Here's one individual that's made analyses. I'm sure it's a name that you know quite well. Former Chief of Staff to Prime Minister Harper, Ian Brodie. He said the Supreme Court of Canada has increasingly taken on a legislative role, stating the court is well on the road to establishing itself as a legislative rather than judicial institution.
Yeah.
What do you make of that sort of critique that
Sure.
we see, popping up again and again?
Yeah, well, I'll say one thing. I quite respect Ian Brodie and his work, but I would call on him to read my book. And I think what my book
You
does
hear that,
is
Ian?
if
He's
I would,
listening. He's listening,
yeah,
Professor.
it might very well be. I would say this. I mean, I understand that, again, going back to what I said previously, judicial decisions, when the court strikes down legislation, is probably the most, visible act of judicial power. But what I ask in the book is judicial invalidation the only metric by which we can evaluate the courts and their role in our constitutional democracy? And what I try and do in the book is to say, first of all, judicial decisions are not self-implementing. When legislation is invalidated, it does result in a couple of actions. Does Parliament follow the court's guidance when it introduces a legislative response in the form of amendment? More importantly, how do private actors respond to judicial activism? And so I think calling the court a legislative actor is only perhaps true if you can trace direct and indisputable policy impact to the court's decision. But what I do in the book is to look at very significant areas of public policy in which the Supreme Court of Canada has invalidated government action. I look at the issue of medical assistance in dying, supervised consumption sites, the opioid crisis. In the case of where I live in Quebec, the sign law and English access to English public instruction under the Charter of the French language. Those are very, very high-profile examples of judicial activism. Someone like Ian Brodie would point to them perhaps as the court acting as a legislative actor. But what I would say to individuals that hold that view is, first of all, I think first buy the book. I think that's important to have sales. Read the book, and then see how legislatures in these high-profile instances are able to redirect and perhaps constrain the overall impact of the court's activism.
Just one more criticism before I move to our final topic here. This idea of the court party, this idea that interest groups use charter litigation to bypass what would be democratic debate we'd see in public or in Parliament. What do you make of that criticism? Is it something you came across in your book?
It's not what I focused on in my book. I mean, my book was about someone that uses the court party thesis, a very important thesis developed by Morton and Knopf in their book, The Charter Revolution and the Court Party. That's really about legal mobilization, groups that use litigation as a way to challenge public policy. I don't focus on that in my book. My book was largely about the legislative responses to judicial activism. And so whereas someone, advancing the court party thesis would be looking at the various interest groups that appear before the Supreme Court, my book was largely about looking at, the interest groups that appear before parliamentary committees, attempting to sway the contents of legislation.
Should we be pointing our fingers more at politicians than the court, i.e., Jim, that politicians have a tendency of punting issues they don't want to address to the courts? You deal with it. You figure it out. Is this something we should be thinking more about?
Well, in the case of, the examples I use in the book, and I'll discuss them right now, supervised consumption sites.
Yeah.
I would say that wasn't an issue that was punted to the courts. That was an issue that began because, the police in Vancouver, as well as local public authorities, the British Columbia government, lobbied the federal government to try and bring a sort of an innovative approach to this public health issue that they were facing. I understand what you're saying. Generally, one of the criticisms is, the charter allows courts to abdicate issues. There's evidence for that. But in all of the cases that I looked at in constraining the court, these largely began as problems of public policy. that became judicialized and that returned to the public policy arena. So I think sometimes governments, what they may do is delay legislating in response to a judicial decision. But for the most part, I mean, my book would argue that we're not seeing the abdication of responsibility. We might just be seeing governments delaying how they respond to judicial decisions. And I want to use one example because you brought in, Ian Brody and his work. One of the examples I look at is supervised consumption sites. And that's from a very important decision from 2011. And in 2011, the Supreme Court of Canada ruled that the Minister of Health and the Harper government had used his ministerial discretion in a way to violate the charter rights of individuals that had come to rely on a facility such as Insight. This is 2011. The Harper government took 4 years in which to introduce its legislative response. Now, I would not say that the Harper government deferred on that issue to the Supreme Court. And what I argue in the book is that it brought in a very, very strong legislative response that ultimately constrained the impact of judicial decisions. So I would go back to the argument you raised by Ian Brody. We could use a real life example from the Harper government in which the Supreme Court was activist, in which the Harper government's legislative response was ultimately to constrain the impact of the court's activism in the Insight decision. And I devoted an entire chapter to that legislative judicial interaction between first the Harper government on the issue of supervised consumption sites, which was then handled by the Trudeau government. And if I could, I just want to go to my book because the title of that
pull
chapter.
It up. Show us.
Yeah, because I gotta sell it here, right? Let me see, what chapter number is it? It was chapter 6, Supervised Consumption Sites and the Respect for Communities Act. How the Harper government outflanked the McLaughlin court.
I remember those times, tense times. Just lastly here, looking at Section 33, the notwithstanding clause.
Yep.
You warn in your book, I believe, about the preemptive use of the notwithstanding clause, which for our listeners who are not in the professor's class, allows federal or provincial governments to override certain rights and freedoms spelled out in the charter for a period of up to 5 years, I believe.
Yes.
In your view, what criteria should guide what is a responsible use or decision of invoking Section 33? What should go into that decision?
All right. Well, let me state my position on Section 33. It's a legitimate constitutional provision.
Mm-hmm.
Without Section 33, most likely there would not have been intergovernmental agreement that led to the patriation of the Constitution in 1982. But what I want to say, though, about the use of the notwithstanding clause, while it is a legitimate instrument, it should never be used preemptively. And there's a couple of reasons for that. The first is, I think, an appropriate use of the notwithstanding clause is in response to judicial activism when a government fundamentally disagrees with a court's decision. But more importantly, there can be an open and transparent parliamentary debate that the only option available to a government to achieve its pressing and substantial legislative objectives is to use the notwithstanding clause. And I'm going to point to one example where I think demonstrates perhaps the notwithstanding clause and its use in an appropriate way, though I disagree with the policy outcome. When the Bourassa government saw the sign law invalidated in Ford versus Quebec in 1982, it had one of the most, I think, transparent and honest debates on the use of this clause, where at the time Premier Bourassa argued that he recognized the difficulty in overriding individual rights for the collective protection of the French language, that he had a special responsibility as the Premier of Quebec to protect the French language, and the Quebec National Assembly was very conscious of what it was doing, overriding rights, but that it was attempting to advance a pressing and substantial legislative objective. I think the notwithstanding clause should rarely be used. I'm not a political scientist that argues that it should never be used. Again, it is a legitimate part of our Constitution, but I think there are very, very restrictive conditions under which it should be used. The
And,
bottom line,
yeah.
in response to judicial activism, but after a full and open, frank parliamentary debate in which governments use it in full knowledge of what they're doing.
Mm-hmm. Sort of a last resort after the fact, after it's been
Yeah.
hashed out. You're in a province, I believe, Professor, that has used it preemptively quite a
Yeah.
few times, if I'm not mistaken.
They've used the Legault government has used it preemptively in regard to Bill 21, the state secularism law, and Bill 96.
Mm-hmm.
And again, I'm in opposition to that. I think the problem with using the notwithstanding clause preemptively is that it robs us of the role of the court in participating in the development of our Constitution. So judicial activism is not a term that I use in my scholarship, but the value of judicial review is that in some ways it can require governments to be more precise about what they want to do in a way that is compliant with the charter. So again, going back to a statement that I made previously, if a government fundamentally disagrees with what the court has said and it feels that it cannot achieve its pressing and substantial legislative objectives in any other way than using the notwithstanding clause, then it should decide whether to use the notwithstanding clause. But to use the notwithstanding clause in a preemptive way is problematic for a number of reasons. I think the first that I would point to, particularly in the province of Quebec, is that unicameral parliamentary bodies at the provincial level. There is no check on what a majority government can do at the provincial level. There's no Senate, even though the Senate is unelected, it can serve as a check. So going back to anyone defending preemptive use of the notwithstanding clause, it suggests that there are not other constitutional guardrails in place, and those are ultimately necessary. And so again, while I view the notwithstanding clause as a legitimate instrument, it should never be used preemptively, and it should only be used rarely in response to judicial invalidation.
Mm. I think that's a good place to leave things. Ladies and gentlemen, that is Professor James Kelly. His book, Constraining the Court, Judicial Power and Policy Implementation in the Charter Era, is shortlisted for the Donner Prize this year. And we're so grateful he joined us here on The Hub today. Thanks so much.